We will now start with a poll, just to get to know you. And the first question how does the poll work?
I open the poll.
Oh, okay. The poll is being opened by Emily. And we have 3 questions. And the first question is, of course, what is your background? Are you NGO? Are you government? Are you business? Or are you other? Yes, and there are even more possibilities. So please put in your answer now. Okay, so what I can see is most people that are present in this webinar have a background in the NGO world or in the medical profession. Okay, then the second question is, have you read the PAF guidelines for legal actions? And there's one, you can choose between yes, no, or it's on my reading pile. Please tell me what happened with the PAF guidelines. Oh, okay. Yeah, so most people have read it actually. Okay, that's great. And a few still have it on the reading pile and a few haven't read it, but you will hear something about that. Then the third question, has your organization ever considered doing legal action for access to medicines? Yes is the answer by 76% of the people. And no, 23%, and need more info first. That's 15%. Okay, thank you. Okay, we have more than 60 people. No, I'm lying. We have more than 30 people in the audience now. People from different countries like the USA, Switzerland, United Kingdom, Pakistan, Russia, and Kenya. The majority of the people that are active for PAF live in the Netherlands. And this event is hosted from Amsterdam and will take 1.5 hours. Okay, next slide. That's the one announcing Rosalind Turkey, because I will give the floor to her. She is the researcher for PAF, and she has written the paper on guidelines for legal actions together with our chair, Wilbur, and she will tell you more about the paper in the coming minutes. Ros, you have the floor.
Thanks, Sabina. Hi, everyone. Thanks for joining our webinar. It's great to see quite a few of you here today and some people that also attended our first webinar on the power of law. Please excuse my post-COVID cough if I have to cough in the middle of my presentation. Unfortunately, it's something many of us have to go through today. So I'm Rosalind, and I'm a PAF researcher, and I'm also a human rights lawyer. And I'm just going to explain a bit about the guidelines for legal action that PAF has developed. So could we go to the next slide, please? Yeah, and the next one. Thanks. So under international human rights law, the human right to health, which includes access to medicines, is legally binding on states and not on private companies. So that means that pharmaceutical companies cannot currently be held accountable legally under human rights law mechanisms. However, as many of you know, private actors do have responsibilities to respect human rights and to not interfere with the right to health. And these responsibilities have been translated, with regards to Pharma at least, into the human rights guidelines for pharmaceutical companies in relation to access to medicines. This was done by Paul Hunt, who was the former UN Special Rapporteur on the right to health. So PAF has another project which is called the Good COVID Company Practices, or GCCP. And the GCCP are based on these Paul Hunt guidelines, and also on this argument that Pharma has human rights responsibilities. And so the GCCP were developed to stimulate Pharma to change their behavior, but not in a legal sense. What GCCP has shown us is that pharmaceutical companies often do not, in any substantial way, adhere to these criteria. which begs the often raised question of whether the current international legal framework is enough, at least in terms of human rights law. And I'm not asking you to answer this question right now, but it's just something to bear in mind. Maybe we can return to it in the discussion later. So the guidelines for legal action for NGOs were developed to show that, oh, sorry, someone's saying that I'm speaking too fast. I'll slow down. Sorry about that. The guidelines for legal action were developed to show that even though no formal complaints against Pharma can be raised at the international level under human rights law, that there are some legal actions that NGOs can take to make pharmaceutical companies change their behavior legally. For example, NGOs can lobby national law and policymakers to introduce binding norms at a national level that are enforceable against pharmaceutical companies. So in this sense, for example, PAF is advocating for a duty of care norm in the Netherlands. And there are also many other types of legal action that can be taken, and these are all detailed in the guidelines. So the document was really developed as a service, as an informational tool for other NGOs that want to campaign for access to medicines using legal action against those pharmaceutical companies that are restricting or endangering access to medicines or healthcare overall. So they were written based on PAF's own experience and also the experience of other NGOs. We had some really interesting speakers at our first webinar who told us about their experience using law. And secondly, they were developed initially for COVID-19 products in the GCCP project, but the idea is that they can be applied to all essential medicines. And finally, the guidelines are a living document, so they'll be updated as new knowledge emerges and hopefully as we get new jurisprudence on using law to promote access to medicines. So if you do end up starting a case, we really want to hear about it. And also if you have any feedback on the guidelines, please let us know. Could we move to the next slide, please? Thank you. So the guidelines are basically quite comprehensive guide as to who may be able to take legal action, when to consider it, and which legal procedures might be appropriate. So first, something to bear in mind is that legal action should really be considered a last resort. It's very labor intensive and it takes a lot of resources. So other avenues should definitely be considered first. And these are all detailed in the document. So it starts with a section on what you should do before you consider legal action. And that's stimulating Pharma to do the right thing without using legal procedures. So you can, for example, lobby Parliament to change laws. And at a national level, you can organize campaigns, which creates public awareness, which then puts public pressure on Pharma. The GCCP, for example, has taught us that there's also potential in pointing these companies to the human rights principles to which they often commit on their websites, for example. You can also use this debate on human rights responsibilities to change national legal systems. And if you check the PAF website, there's a detailed overview of a lot of issues that lead to access problems and the corresponding solutions on how these issues can be mitigated. It's a really useful tool. It was made by Caitlin, who is in the meeting today, and it's still being updated. So do check it regularly. Okay, so once all of the above has failed, if it fails, it may be time to take legal action. So you can see in the guidelines all the things that you need to analyze before actually considering legal procedures. So the first thing is the product. Most problems are caused by single source products, which means that they're subject to a monopoly. And this could be obtained through different things such as a patent or data exclusivity or evergreening, or simply being the only drug in the market. You need to consider why there are no alternatives available. The second thing to analyze is the company. So whether the company is actually responsible for the problem and whether this behavior can be legally tackled. So the company could be not adhering to national pharmaceutical laws, to ethical norms, codes of conduct, procurement contracts, such as what happened between AstraZeneca and the European Commission regarding the COVID-19 vaccines. They could be not adhering to human rights principles, or displaying anti-competitive behavior, or violating tort law. The final thing you need to analyze is your country's specific legal situation. So something to start with is considering the national laws that apply to pharmaceutical companies within your territory. And then you can think about the applicability of international agreements such as TRIPS or human rights treaties. In this sense, you could look at whether the right to health is enforceable in your national constitution. And then finally, perhaps it's possible to refer your case to a supranational court, such as the Court of Justice of the EU, or the European Court of Human Rights, or the dispute settlement forum at the World Trade Organization. And finally, after you've analyzed all of this, you can start thinking about which legal procedures are appropriate. Next slide, please. Yeah, so then at the end of the guidelines, you have a list of the laws or practices that are problematic and which are leading to a lack of access to medicines. And for each problematic law or practice, there's a suggested legal recourse or a list of legal recourses. So do check the guidelines. And Emily, if we could just go to the PAF website, I'm just going to show you where to find the guidelines and what they look like. For anyone who might not have seen them. Yeah, so they're on our website. There's a section at the top called Legal Action, and then you can click on the guidelines or you can download them. So could you go down, please? Yeah. Okay, so there's a section on before you consider legal action. So if my explanation was a little bit fast, it was just to give you an overview, but you can definitely go and read the guidelines for yourself and take the time to look at all the aspects of it. So and then after, could you go down, please, Emily? Yeah, and then all the things to analyze once you're considering legal action. And then at the bottom, yeah, keep going. Yeah, and then here's the section about the underlying laws. So if you can see, there's an explanation of the laws or practices that might be causing problems, and then there's quite a few options for legal recourses that you might be able to take, and depending on what your status is. And then finally at the bottom, there's a list of the top websites to refer to when considering legal action, and this is really important. Yeah, here it is. And this includes the Paul Hunt guidelines for pharmaceutical companies, so very useful to look at. So do take a look on our website. Thank you for bearing with me through this very theoretical explanation. We're now going to hear from a more practical perspective about people who've actually used law to promote access to medicines and campaign for access to medicines. So I'm going to give the floor back to Sabina, who will introduce the panelists to you. Thank you.
Yes, thank you very much, Rosalind. Yes, we will indeed get now to the panel. We will hear experiences with legal procedures from our panelists, and they have 10 minutes each, and I will really be very stern on that. And after their stories, there is time for questions for clarifications. And like I said before, if you have a question, please write it in the chat. We will do another poll after the presentations, and after that we will discuss with members of the panel what happens after or during a legal procedure, depending on how much time we still have. But I will still first introduce the panelists to you. First, I want to ask, do we know if James Love is already in the meeting? We'll get to that. First, okay, the panelists. First is Wilbur Bonabeer. He's a medical doctor and public health consultant who has worked in Africa and Asia as advisor for health ministries and international organizations on better access to essential medicines for more than 35 years. He has been at the basis of several public health NGOs such as WEMOS, HERA, eDrug, and the Health Action Network. He is the chairman of the board of the Pharmaceutical Accountability Foundation, since this was founded in 2018. One of the first cases that PAF filed was an enforcement request at the Dutch Competition Authority against Leadient for CDCA, and he will tell you more about this in the webinar. Patrick Dewish from Public Eye Switzerland is originally a veterinary doctor. He has more than 25 years of experience working with NGOs in the Middle East, Africa, France, and Switzerland. And since 2009, Patrick has served as a health policy expert for the Swiss advocacy NGO Public Eye, which is formerly known as the Bern Declaration. For several decades, Public Eye has campaigned to Swiss stakeholders for improved access to medicines, ethical clinical testing in developing countries, pharmaceutical innovation that primarily responds to public health needs, and other related issues. He will talk about patent opposition against Novartis on its Kymriah treatment. And I hope I pronounced it well. And if not, then Patrick will tell you how to pronounce it. Peter Maberduk from Public Citizen USA has as an academic background technology and anthropology. At present, he directs Public Citizens Access to Medicines Group, which helps partners worldwide make medicine available and affordable for all. He has provided technical assistance to public agencies and civil society organizations in many countries, and his work has supported major medicine price reductions and new state access to medicine policies, as well as help defeat harmful proposal in legislation and trade deals. Peter and his colleagues have helped organize the global movement for COVID vaccine access and rallied support for new vaccine manufacturing funding and technology transfer. And Peter recently joined the governance board of the Medicines Patent Pool. And Peter will talk about making use of the right to health in several constitutions in Latin American countries. James Love is director of Knowledge Ecology International. This organization exists since 2006, and his work focuses on the production, management, and access to knowledge resources, and currently on access to drugs, vaccines, and other medical technologies. He was the government's expert in the Hazeltow compulsory licensing case for HIV drugs in South Africa, and the NETCO expert in the Nexavar compulsory license for a cancer drug in India, and has been involved in many other compulsory licensing cases, including 2 pending currently. But today he won't talk about compulsory licenses, but he will talk about the use of the Freedom of Information Act in gene therapy cases. So let's hear from the panelists. You have 10 minutes each, I told you already, and I will let you know when you have 1 minute left. And we'll start today with Wilbur. Wilbur, you have the floor.
Sharing. Okay. Takes always a while. I'm sorry, all of you.
Don't worry.
Okay, are you seeing my slides now? My name is Wilbur, and I'm indeed the chair of this Pharmaceutical Accountability Foundation. And sorry to start first, but it is also good to explain why actually we developed these guidelines for legal action, because this is based on our experience. So I'm actually going to talk about this CDCA medicine from Leadient. That case started in 2018, and we don't know when it will close. The reason that we got involved was this. This is a slide actually from the Dutch Competition Board, which they presented 2 days ago at the WHO pricing seminar. And they showed actually the price of the medicine actually increasing from 46 to 14,000 euros per box of 100 capsules. And it is an old medicine what was used for gallstones, but it proved to be working for a rare indication, CTX. It's a rare indication, and the company actually bought up the old product from the original German company, bought all the competitors, then launched its own Xenbilox, and then actually got from the European Union an orphan drug designation. And after that drug was registered by EMA, it automatically got 10 years of marketing exclusivity in 2017, and they raised the price to 14,000 euros per box. What to do as an NGO about such a thing? It is very clear that the EU orphan drug regulation is actually allowing or permitting or enabling such misuse. Maybe it was not the intention, but what we need to do then is a campaign to actually, of course, change this EU directive, which is actually ongoing. So there is a possibility to actually change this, the orphan drug legislation in the coming 2 years. We looked at Dutch legislation. Dutch legislation does not forbid asking high prices. So what we need actually is going to have in legislation a definition of fair pricing, or at least a legal way to actually allow that drugs can be priced fairly but not excessively. I've also added that not only do we need to talk about fair pricing, but also about fair profits. That will come back in another case that we are going to launch in the future. The competition law actually forbids, that allows you actually to have a monopoly, a patent or a marketing exclusivity, but it actually forbids making misuse of your dominant economic position by asking excessive prices. And as the Leadient company was not based legally in the Netherlands, it actually was the easiest for us then to put in a complaint to the Dutch Competition Authority in September 2018. The complaint is available in Dutch and in English, and it has been used by other countries as well to actually also complain. Now, what happened in the Netherlands was that health insurers refused to pay the excessive price by Leadient, but patients still did get access, as one of our leading university hospitals managed to compound the CDCA drug from a source. Leadient complained about this and lost in the case, and the appeal is still going on until coming again May 22 to the courts. Now, we waited nearly 3 years, but on the 19th of July, I was called in the early morning by my lawyer that I had 90 minutes to make a press release, because the Leadient case ended with a fine of 19.6 million euros. Now, there is a problem that Leadient actually also sued the Dutch Competition Authority for the full report, so we only have at the moment public a summary report. But in that one, it already states that, and the ACM in the Netherlands law is actually acts as a court, so this is a statement that has legal value, that they charged an excessive price which was exorbitantly high, because the price in combination with the low costs and the low risks resulted in exorbitant return. So this is not only about excessive price, but also about excessive returns or profits. It continued saying that it was also unfair because the drug under a different name had already been on the market for many years at a much lower price, while patients benefited very little from the registration as an orphan drug. So this is actually a very good statement from our National Competition Board. And now what will happen next is we have to wait until the full report becomes public. They have to publicize that at one point, and then we'll see what's in it. But we'll definitely try to go and look at the possibility of a civil case against Leadient, because apart from the fine, we also want the money back that was paid in too much, and we've calculated it's about 11 million euros. And we want to know what the Belgian, Spanish and Italian competition authorities do. So the lessons learned in this case
Wilbert, you froze in my screen. I don't know how this is with other participants, but maybe you have to check.
That you have to do proper research papers, and the competition authority. It seemed that I was cut out. So
yes, a little bit.
Am I back? But not yet with the video in front of me. Huh?
Yes, you're back. Yeah, there's your screen.
Okay, sorry about this glitches. So what we've learned from the ACM was that it is difficult for them, and they ask us to actually not to give them too many cases, but to try and change the EU orphan drug law or the Dutch laws that forbid excess pricing. Now, one thing that happened was definitely that the Pharma pirate business model that was used by Lydian have shown not to pay off. And in fact, we can already report that the second case was prevented. This is the maxilitine. That's a drug for a muscular disorder, which was 100 times more expensive, made by Lupin. By the way, that's an Indian, normally generic company. But as we could convince the government that the import from good generic quality from Canada or the compounding in the pharmacy was cheaper, the government refused to pay the high price, and Lupin did not manage to sell its product Namuskla in the Netherlands. They did actually manage to start selling it in the UK, so they still think there is action needed in other countries in the European market. The third case we already have on our screens. It's a drug Tiratricol. It's MC-Tate Egatis. They actually wanted to make it maybe 1,000 times more expensive. And we have actually been lobbying the company and also the hospital university where they're actually doing the research. And so we have to see until they come with the price that they ask. If it's not fair, we're definitely going to make a case of it. And the drug can also be easily compounded. So a lesson learned is then also that pharmacy compounding is useful for this type of cases if it is a small molecule and it is useful as a kind of an emergency. It's not really a sustainable system. For that, we need to have better definitions of fair pricing in our law and a orphan drug legislation that actually stops pharma pirates from hijacking old drugs and then repurposing them at a much higher price.
You're in your last minute, Wilbert.
I'm already done, my friend.
Oh.
So we can even have discussion if it's needed. But
we'll first have other speakers, but there will be time for discussion in a later time.
So far.
Thank you so much, Wilbert. Okay, the next speaker, and I'm glad to see that James Love has joined the webinar. Welcome, James. We are already in the panel, and the next speaker will be Patrick.
Thank you, Sabina. Thanks to PAF for the invitation. I'll just wait for the slides to be downloaded. In the meantime, regarding pronunciation, I say Kymriah. But the international non-proprietary name is even worse. It's Tizagin Leclosel. So I'll stick to Kymriah. I think it's easier. I'll talk to you about this drug. I mean, it's not a drug, actually. It's a medical service. And I'll just show one slide about what's this therapy about. Next, please. This is an illustration of what it is actually. It's actually withdrawing white blood cells of a patient, genetically engineer these white blood cells in order for them to recognize and attack cancer cells, and then they are re-injected into the same patient. So that's why I'm saying there's no product. I mean, it's not a drug in the common sense. It's more a medical procedure or medical service. This was an illustration that was made by Médecins du Monde. Actually, we did this opposition at the initiative of Médecins du Monde, as they had some experience about patent opposition. Next slide, please. So why this opposition? Médecins du Monde had already opposed patents on the hepatitis C drug, so Fosbuvir, a brand name Sovaldi, in 2014 and 15 and 17, I think. So they had some experience because there have not been so many patent oppositions at the European Patent Office on pharma products coming from NGOs. So this was about the second or third one, I mean, among the first ones. Actually, the procedure allows for anyone to oppose a patent within 9 months post-grant. Unlike other countries, I've seen in your legal guidelines that you mentioned India with pre-grant oppositions. This is not allowed in Europe. You can only oppose after the patent has been granted, and you have this 9-month window. The idea was to question the patentability of Kymriah as a medical procedure and challenging the issue of novelty, inventive step. We'll come to that a bit later. Also, politically, it was to alert the European public opinion and policymakers, that's important, on the excessive price of Kymriah. I mean, the price tag was about euro 320,000 for one injection when it was launched. In the US, it was 370,000, if I'm not mistaken. So it's a huge price tag for a drug, for a therapy that has been actually invented in a university. The University of Pennsylvania was instrumental in inventing and doing the first development steps of this therapy. So basically the price tag cannot be justified just by the production nor by the trial cost. The trial have been there haven't been many participants in the trial, so they haven't cost very much according to the intelligence that has been published since then. And there has been substantial public investment, both mostly in the US, but also at the EU level. So this patent opposition was really to enable governments to negotiate lower prices. And also one of the aim, the university hospitals in Switzerland, and there has been in Spain and probably somewhere else, were also developing the same kind of therapies. And they felt a bit offended that Novartis, a commercial entity, came playing into their field. So basically this patent opposition could also produce some benefits in them trying to produce public, so-called public CAR-T treatments. Next, please. The grounds, I mean, I'm coming a bit in a technical matter. I don't want to be too technical here. But basically, there were two flaws in the patents that was opposed. First, there was insufficient disclosure. I mean, there's when you do a patent application, you really have to present all data that are disclosing the suitability of the claimed therapy for treating other types before you claim that this can be therapy for all kinds of treatments, for all kinds of cancers. I mean, that was the first flaw of the patent. But the second, and maybe that's more an obvious one. Whenever you file a patent, it shouldn't be known in the state of the art. So there shouldn't have been publications of the claims and technology that you are asking for. And actually, there were several articles, nota bene, also co-written by the inventor of the Kymriah, that were published before the priority date of the patents. So basically, that's a case where a patent actually should be rejected. So what our patent attorney found, actually any examiner at the EPO could find it easily. So basically, this patent should never have been granted in the first place. If you want to see more details about that, there's a link in this PowerPoint that will be made at disposal, and I'll drop it in the chat also later on. Next slide, please. So the outcomes, we filed together with Médecins du Monde on July 2nd, 2019. And actually, according to the standard procedure, a company has 4 months to respond from when they receive this. And then it would go through an examination, and then you would have oral proceedings. But actually what happened is that by the end of November, Novartis requested some extension of this 4-month period. On November 29, Novartis and University of Pennsylvania, which co-own this patent, requested to the European Patent Office the revocation of the patent before the proceedings had actually started. There was no confrontation, there was no debate. They just revoked it. But they went even further at the end, and we happen to know it a bit later. At the end of September 2019, the same people also requested the withdrawal of another patent application, which was under examination at that time, and that contained similar claims. Well, the outcome is there are still other patents covering the therapy. So it's not the end of the monopoly, but we believe it's weakening it. And above all, I mean, this volte-face confirms that the patent should never have been granted in the first place. One of the most main lessons learned, I mean, patent opposition have been used very much in the global south against, I mean, thinking of HIV therapies or any other sorts of medicines. But in Europe, it hasn't been used so much. And probably one of the reasons is because the monitoring is quite challenging. I mean, I don't know if any of you have been on the European Patent Office website, but it's not really user-friendly. There's no alert system. There are many patents being granted. So if you want to monitor that, you really need to be behind that. It costs, you need a patent attorney. So if you find one with a good rate, then you may save something, but it costs quite a lot. And the reactivity is quite a challenge because 9 months seem to be a long period, but it's quite a short window to put the file together and file it within these 9 months. Thank you for your attention.
Thank you so much, Patrick, for this very interesting story. Before we go to our next speaker, we planned a little break, and it's a non-commercial break, but it's about a court case that has been won quite recently in the Netherlands. It's not on access to medicines, it's on another issue, it's on climate. But please have a look and feel inspired. Yeah.
I think the world looks a bit brighter today than it did yesterday.
This is a historical moment for all of us. For the first time in history, a judge has ordered one of the largest polluters to stop contributing to dangerous climate change. The judge was crystal clear. Shell causes dangerous climate change, and Shell should stop immediately with doing that.
The verdict against Shell today is a landmark victory for climate justice. This is quite incredible. It's incredible for those who've been involved with the case, but it's also an extraordinary win for people across the world who are being impacted by climate change and impacted by fossil fuel operations.
We also think that this will have a ripple effect in other jurisdictions, and we expect a lot of similar climate cases around the world against the big polluters. So yeah, this gives us also hope that the energy transition that needs to speed up and needs to speed up quickly can actually happen through these forceful measures.
yes, that was it. A short break, but I hope you got inspired by it. And yes, okay. So that's just also to give you some time. Sorry. Then we will hear our next speaker. It's Peter Meybarduk, and he will talk about making use of the right to health. Peter, you have the floor.
Hi, everyone. I'm going to see if I can share my screen here. I'm a little unclear. I'm not quite sure how this is going to go. Okay. All right. Are you guys are seeing the you're seeing the slides right now primarily?
We're seeing the slides, but we need your presentation mode because we see much more than your slides.
Yes, ma'am. How's that? Okay, we will. Well, that does it again, right? Sorry, this is going to be awkward for like just a minute, I think. And then we will, give me a second. Can I move this over here? There we go, kind of, but I still need something else. Yeah, I don't know. I think if it's okay with you, sorry, but are you mostly seeing the slides and the context around it? That would be the easiest because I have to see some notes.
Oh, okay.
Too.
Yeah, just do it like that. It's okay.
You're just seeing the slides and the stuff around it?
Yeah.
Like you're
don't
not.
worry.
Okay. So all right. Sorry for the delay, everybody. So so yeah, Peter with Public Citizen in Washington, D.C. So the PAF guidelines reference the challenges in holding drug companies accountable at an international level, and the challenges of that and the opportunities for doing so nationally. Of course, each state is different values, different constitutions, different balances of power between government, industry, and civil society. I was hired 15 years ago to try and help overcome patent barriers in various countries at the national level, where you have these different challenges. So I'd like to speak briefly about 3 neighboring South American states, all part of the Andean community. They've got a shared legal regime, but the political orders have been very different, and some of the legal rules have been different. And you know, the successes and the different theories we applied in each case hopefully have lessons for what we try in different states one by one to introduce price cutting, generic competition.
I'm sorry,
yes.
Peter. I can share your presentation. I think that's better for the. It'll be bigger than in the screen.
It'll be bigger, yeah. Well, okay. So next slide. We'll just kind of go through them.
Yeah.
Go through them pretty quickly. I should say my colleague Luz Marina Umbacia is on the call also, and she is the Colombian lawyer who has helped execute much of the Colombian litigation, and a very valuable figure for folks to know, particularly in Latin America, pursuing these cases. So, and hopefully we'll end with a theory of health rights litigation. So we can go to the next slide. So each of these countries has the Andean community regime of rules, which preserves compulsory licensing, a little more restricted than TRIPS, but has a public interest mechanism. So you don't need an emergency or anything like that. If the state finds it's in the public interest, then you can issue a compulsory license and authorize generic competition with patented products. Next slide. In Colombia, we had a government that was quite opposed. The neoliberal government of Uribe, which was quite publicly aligned with big business and with Washington, but a strong civil society. So no state inclination to do the sort of thing we wanted to do, but a lot of support. Our first step, and you can go to the next slide, our first step was, so I was invited in 2007 to meet with civil society and talk about routes for competition for Kaletra, a patented AIDS drug, and Colombia was paying far more than its neighbors, several $1,000s for this patented second-line AIDS drug. we decided to pursue a compulsory license. We filed first, we asked Abbott, right? Like as in the guidelines, the PAF guidelines. First, we approached Abbott and did not get much of a response. After waiting some period of time for a license request from Abbott, we went to the government with the theory, you have a right to health in your constitution. This drug is compromising the state's ability to provide access to medicine for all. You should issue a compulsory license. Now the state turned us down, was not interested. So it's at that point that we went to the courts, and we went to the courts with what's called an action populaire. It is a tool to enshrine, to make practical the responsibilities of the state under the Constitution on behalf of all citizens. So it's helpful that Colombia had such a mechanism, since one of the problems we have in these cases is standing. Can an individual file a case for their own access? How do we get at the collective right to lower prices to medicines? Probably, in Latin America, you have tutelas. So any individual can often have their right to access to medicine satisfied by a court ordering the procurement of a particular drug for them. But that doesn't help with the collective problem of access to medicines for all. You can't order expensive patented drugs for everybody if you had limited resources. So what is the mechanism under law for society-wide change so you can bring down costs and get access to medicine for all? And that's part of what we've been testing. With the Action Popular, we tied it with political action, right? Protests in the street and pressure on the Colombian government. The first judge came out and said in something that was kind of groundbreaking that there is actually a collective right to health, and that Abbott abused its dominant market position by pricing this drug far more than it was pricing the drug to its neighbors. Abbott, of course, appealed, and the government appealed as well, as the government was also held accountable. An appellate court found that it was the state's responsibility. I think we can go through to the next slide. Found that it was the state's responsibility to ensure access to medicines, ensure the collective right to health, and that the state must fix it. Sorry, next slide too. I'm realizing it's a little bit hard to do the connection here. Let me just, okay, so I'm gonna apologize, Wilbur. Why don't we cut the slides and just, it'll be a little simpler, and I apologize for that. And but we'll make the slides available as a resource because they include the information on the cases. Okay, so in an appeal, it was determined that the state must actually fix the price for these drugs. And since then, a regime of medicines price control has been introduced in Colombia that's affected many medicines. So there was no state price regulation in Colombia prior, and now there is. The states actually act involved. And so for Calitra, there was a 90% price reduction. For imatinib, a cancer drug, there was a 44% price reduction by the state stepping in and regulating price. And even though, the government has had to enforce these, and part of what happened, is this, again, this marriage of legal and political action. Even though Uribe was opposed to a compulsory license, he was embarrassed by activists coming out and saying Colombia is paying triple what its neighbors are paying. And that sense of national pride meant that even a neoliberal government, it had to show that it was able to protect its citizens. And the president went on national television and said, Abbott is taking advantage of us, and we are going to enforce these price orders, which Abbott initially was ignoring. So the court ordered price reduction, Abbott ignored it, the government stepped in, prices came down by 90%. Even though we didn't get our compulsory license, we were able to show that the state had tools to control medicine prices and was not okay not to do so. But the second achievement was this distinction between sort of individual rights and collective rights. An order from a judge saying there is a collective right to health, and it is the state's responsibility to address it, means that we can push past the tutela system of just assigning medicines to individuals and can start to get at the collective cost problem and the collective patent problem. One of Abbott's counter arguments in these cases was, in the end, people get access to this drug. They come to us for free access. In some cases, the state is obligated to get access. So ultimately, there's no access problem. How can there be a right to health action if there's no access problem? Well, our answer is the Colombian state can't afford to pay $3,000, $4,000 for every course of treatment to every person. If we do, and in some cases the Colombian government was, but if we do, that compromises the state's ability to provide other essential health services because budgets are limited. And the courts found that persuasive.
Peter?
We'll tie up as best we can.
Good, thank you.
In Ecuador, just to say by contrast, right, we had a very friendly government and but opposition within it, and used administrative petitions to get compulsory licenses over time because it was an administrative process, not a judicial legal process, and it required the implementation of new regulations. It took years to overcome quiet internal opposition and corruption. But 6 years later, we wound up with 11 compulsory licenses plus a drug negotiation regime that saved half a point of GDP. I think, a couple lessons from these cases are that it works, it takes time, law is political, and we have to have a theory for how to deal with this distinction between the individual right to access and the collective burden on the health system. And a theory that I'd love for us to experiment with. Countries that I'm going to need just an extra 1 minute for this. Countries that have social and economic rights in their constitutions. The United States does not, right? Like we have a floor. We can't sort of just give people access to medicines collectively from our constitution. Latin American countries are obligated to protect the right to health, but courts will not order the state to buy a patented medicine for everyone because it's the state's responsibility to decide how to spend its scarce resources. So the state has discretion to choose how it protects these rights when resources are limited. Okay, however, for all the stuff we're trying to do together, TRIPS flexibilities and patents, we're not asking the state to spend more. We're asking the state to save more. So the theory that we'd like to see tested is, given that the state has the right to introduce generic competition, and given that it has the obligation to protect the right to health, and we're asking the state to save money, shouldn't then courts be able to order the state to protect the right to health by requiring the state to issue compulsory licenses or make government use of patents? And that theory has been addressed in part in our briefs in Colombia and Peru, but we're looking for more help testing it head on in countries that protect social and economic rights in their constitution. So sorry for being a little disorganized, but we would like to pursue this with you, and we have a library of resources to put up and contribute to the cause.
Yes, well, Peter, it was a very interesting talk, so you're forgiven. And I'm sure that people are eager to test this, to continue thinking about this theory and maybe even to test it. Thank you so much. Our last speaker in this panel will be James Love. I hear he's here. Yes, I see it. He had a well, tell yourself, James, what happened to your ear?
Well, I was in surgery yesterday, and I'd lost hearing in my right ear after swimming in August, and doctor said I had a bunch of bone spares, so they were taking bones out of my ear yesterday. I was a bit uncomfortable yesterday. I wasn't sure if I could make it today. This is my pyrrhic patch, except it's over my ear instead of my eye. But
James, I hope you can make it, and please let us know if it's too much for you, because you have to be careful with yourself. Huh?
I'm good. I noticed on the agenda I was down for talking about the FOIA, but I was wondering if I could begin by making just a few comments to complement what Peter has said about the compulsory licensing issues. It's okay.
Please do, yeah.
And then you want me to do this in 10 minutes, right?
No more than 10 minutes.
No more. I'll do it as fast as I can. Okay. Well, I think your listeners or the people here, they know what it means to issue a compulsory license, right? That the government essentially, or a court, one of the two, sometimes both are involved, will have to take some actions to override the exclusive rights on a patent. Sometimes that can be done on a non-exclusive basis of like, I mean, just sort of like giving a compulsory license to one company with no one else. In other cases, they can do what we'd refer to more as an open license where anyone could get it on the terms set up by the government. There's a million things you could talk about, but I wanted to focus essentially on saying that you have to look at the legal framework. Sometimes there's always procedures in the legal thing you have to kind of follow, and they're almost never the same for every country. And so you just have to make yourself familiar with the laws and the regulations. A big problem typically in a country is they've never issued a compulsory license, and maybe they lack any procedures. And that's actually turns out to be a huge problem because governments, as Peter suggested, there's a lot of interagency stakeholders, and they have to resolve these things between each other about how to proceed, who's going to do what, and what the standards are. And that just adds time, which is not your friend on these compulsory licensing cases, and adds uncertainty whether anyone. In some cases, that can go over a year or more of people just trying to basically not able to come to grips, just to try and figure out how to do it. Once the procedures are well known and accepted, though, then you have to move on to like beyond the legal issues. What is the policy case? And I think the policy case is really something that's often neglected by people. I mean, you have to have a theory of why a government should intervene that has more to do with budgetary issues, economic issues, public health issues, and it has to be precise because it's going to be challenged by the right owner in a lot of cases. They're going to come back and they're going to sort of argue that you got it wrong, or that there's some other thing that you didn't consider that would make a difference. Now, we're currently right now this week involved in a compulsory licensing case in Dominican Republic on Paxlovid, and in the United States on Xtandi. I think Peter's group is supporting both of those initiatives as well as some other NGOs. Two cases I was in before I wanted to mention briefly. One is in South Africa. There was a case that was brought by a patient group of HIV patients, the Treatment Access Campaign, a very important social movement. And they brought a legal case on excessive pricing, and also their case was initially brought as a compulsory license, as an excessive pricing case. Now, in South Africa, they have a law on excessive pricing, or they have a law on competition, which includes excessive pricing. And there had never, ever been a case decided in South Africa, in 2003, 2004. There'd never been a case at that point decided on excessive pricing. So the commission was really concerned that whatever they decided in that case would have to be a precedent they'd have to apply to other products. And it just looked like a lot of work for them. And they just didn't know how to do it. Diane Terreblanche, who was the head of the Competition Commission Enforcement staff, she reached out to me, and I was hired and put together a team of people working on the case. And what we came up with internally was different than the case was actually brought by TAC. But what we came up with internally was to focus on this issue of the distinction between what we call intellectual property goods and physical goods. Physical goods were rival in consumption. If I had a chair or a car, you couldn't have the same chair or the same car. But inventions, on the other hand, were not rival in consumption. I mean, they're just basically information. So we would argue that if something could be copied for free, it would be treated different under the competition law in South Africa than something that was a physical good, and all the tests would be different. Because what you're essentially doing with an invention is you're not telling someone that they have to provide something for a price. You're saying you're not allowed to withhold the ability of people to get it made themselves unless it's available at a price that's not excessive. So the idea is excessive pricing statute would come into effect. And we also made a distinction between essential and non-essential goods. And so HIV drugs were in this category of intellectual property goods you could copy, and they're essential. And we said for those groups, which is a much smaller subset of all the things in South Africa, the test you would apply is the product on the market by the person that's selling it at a price most people could afford? And that was clearly not the case in South Africa, based on the data that they had on utilization. And that was the way the excessive pricing case was decided, it was a similar standard that was used in 2 other parts of the Act on refusal to license in essential facilities. But essentially, that case, there was a press release put out by the Commission, and then the case was settled between the plaintiff, TAC, the citizen group, and the companies Glaxo and Boehringer in the case, the AIDS manufacturer, and they ended up with a license that covered not just South Africa, but all of sub-Saharan Africa.
Great.
And
James, you have
I'm
4
sorry.
more minutes to talk about the Freedom of Information Act.
The
Could
Indian
you
case,
step into that one?
the Indian case was bought by a private company, a generic company, NATCO, and I was the expert on a pro bono basis for the NATCO case, and there the standard the standard was very clear in the statute in India, which is the product had to be made available on at a reasonably affordable price. The words reasonably affordable prices is in the Patent Act, or the product had to be reasonably affordable. And so, and Section 84B of the Indian Patent Act, that's what was argued. And there it was, you compare, what the incomes were, what utilization was, and what the astronomical price was. Now, after that case was decided at the administrative level and worked its way to the courts, India was contacted by the President of the United States, the Vice President of the United States, 3 different Secretaries of Commerce, 3 different heads of the U.S. Patent Office, 2 different heads of the United States Trade Representative Office, and 2 different secretaries of because it dragged on for a while in terms of the appeals, states. So it was massive pressure, and eventually some accommodation where the U.S. relaxed some nuclear proliferation safeguards in return at one point, and then India agreed not to issue any more compulsory licenses on cancer drugs. And so there was about a dozen cancer drugs queued up for this test, none of which were brought forward by the government. Now I'm supposed to, in my 1 minute left, I guess, right? 2 minutes. We're involved in a lot of FOIA. People have rights under laws to request information from governments under the Freedom of Information Acts. Not every country has them, but lots of countries have these acts, and the rules are different from country to country. One of the initial things in the United States we have to overcome when we litigate this in the United States is you have to ask, or pursue them in the United States, you have to ask for a waiver of the fees, because we would say we're a public interest organization that actually shares the results of the data. And because we do disseminate and we're quoted in the press, we almost always get the free request at the national level, but not necessarily at the state level. Then you have to have like a search term which narrows it enough so they can't just come back and say it's going to take forever to do it, or it's just unreasonable. And then if you go into court, one thing you'll argue is the timing of the delivery, like how many pages do you get per month? So sometimes we'll ask for something, we think there may be a few documents, they'll come back and they say, no, there's, like one case, they said there's 285,000 documents. It would have taken us 84 years to get under the production schedule. So you have to press them on whether you should get them sooner rather than later. You have to press them on how many documents you get per month. And then when you get all through with that stuff, you also have to work on the redactions, because a lot of what they give you is almost useless with the redactions in it, because they'll eliminate a lot of the stuff. And the growing problem we have in the redactions is a growing theory of what represents confidential business information, because it's not trade secrets. It's just like, anything that relates to the units sold, the prices, royalties paid, commercial terms that are certainly not trade secrets, but they are considered by a lot of companies confidential business information. And that's one of our biggest fights. And I'll stop right here. Because my time is up.
Thank you very much, James. I must say I'm intrigued by these stories about Freedom of Information Act. Can you just say one thing, like when do you use these Freedom of Information? When do you use Freedom of Information Act? Can you just say that very shortly?
We have hundreds of Freedom of Information requests out, and they can be filed, as they can in most places, just by email or administratively, or going on a web page. So we file them, for example, for the contracts that were involved in all the COVID products. We file them for some of the arguments that are done within an agency on a particular pricing issue or something like that. We've done a lot of them for like trade pressures against other countries. So we have a big archive. of documents. In the old days, we got them from paper and they were hard to disseminate because we'd have to type them up or, scan them or something like that. But, so we'd ask like anything that the US government did on the Kenya patent reform, or what did they do to pressure Colombia or, Argentina or something like that. So we get documents like that.
Clear.
We get documents for one case we're litigating right now is we ask how many times they mentioned our group at the NIH, because we have a very hostile relationship with the NIH. And they came back and they said that Mark Robert's file, this is just from one guy, that he had 13,000 pages of documents that things that in his email where he mentioned to us, which was a kind of a shock to us. It was also
that's clear. I think that's a good end. 13,000 mentions.
It's just this one guy though. He doesn't like us.
Oh, okay. But he loves to talk about
he's an important guy though, unfortunately. More important than the political guys because he's been there for 2 decades.
Yeah. Thank you very much, James. And thank you also for your clarification. We now have time for clarifying questions. I will have a look what came in from the chat. Is there something that still needs to be answered, and who will it be directed to? No?
I think
I see lots of comments and not so many questions.
Peter made a comment about the state FOIA laws. The state FOIA laws we use a fair amount because they conduct clinical trials on drugs. Often at public university will be trial sites. And so for Keytruda, for example, we're able to get, I think, over 1,000 patient cost per patient records for Keytruda from the University of California. And I think that was one. But we do FOIA requests often on that. We've had mixed results. Some institutions in Texas give us the records. MD Anderson won't. I mean, it just depends where they are. In some places, they'll want money from you at the state level.
Yeah, that also happens. Good. Okay. Yes. Questions welcome from the audience. No. Well. Okay. No. Okay. So what I picked up from these stories is that the legal actions are often done in last resort, because first you ask the company, you ask the government, and you use these legal procedures in last resort, and also you use them to influence legislation, like for instance the EU legislation on orphan drugs. Time is not your friend, as James said so lovely. I think that's really something to really realize, and you need resources for it, because you might have to hire a patent attorney or something else. And there's in doing the cases, there's always or very often a mix between political and legal action. So I think that's also something important to say. And I understand that Patrick wants to give a reaction. So Patrick, you have the floor.
Well, thank you. Just maybe to add something and show the importance of doing all what we discussed, but including patent oppositions. We had some statistics from the European Patent Office. They're a bit older. I mean, from 2016 and 2017, but it showed that patent applications of pharma products were on the rise, and above all, those that were granted were much more, plus 46% between 2009 to 2018, so in the last decade or so. So there are more and more patents being granted for pharma products. But maybe the most interesting statistics, it's on patent oppositions. I mean, of all the oppositions made in 2016 and 2017, I mean, more than 40% led to an amendment of the patent claims. So it was maintained, but they needed to amend it as it was a bit too ambitious. I mean, basically they are trying, and if it goes through, it goes through. If it doesn't, they amend it. But almost half of them had to be amended. And interesting is almost 1/3 were revoked. I mean, this was patent oppositions between competitors, obviously, not NGOs. But it just shows that many patents are granted in a bit of a lax way, according to a very low bar of patentability standards. And I'm sure there's something to be made there, either at the general EPO level or by filing more and more patent oppositions, because the more patents you have, the more and the more unmerited patents you have, the more of these abuses lead to expenses of access, at the expense of access to care and to the financial sustainability of healthcare systems, because they result in high prices. So I think that just advocates a bit more the patent oppositions and compulsory license and all other legal instruments. Thank you.
Yes, thank you, Patrick. Do other members of the panel want to react to the stories they've heard, or to how this discussion is happening now? I can't see everybody.
I could just say that even though legal challenges take time, right, taking legal action can, as Wilbur suggests, can help catalyze political action. So the fact that, you know, in Colombia, we were not, you know, the government told us no, and we could have just gone home. But by filing this sort of equivalent to a class action lawsuit, this Acción Popular, and getting out in the street, we kind of forced the president to take a stand, and also to eventually implement the court's regulations, which doesn't always happen. You know, sometimes, of course, in some countries we can get into kind of rule of law issues as well, where so in Ecuador, in theory, all this stuff should have been done on paper. The government just fully supports compulsory licensing, and it's the official policy, but it still wasn't taking root. So this sort of need for a public arm, you know, to legal action, like the public political arm to legal action, can help the legal administrative action succeed, and the legal action can help the political action succeed.
Peter, there's a question from Luis from Chile, whether the Ecuador and Peru adopted open licensing. Could you elaborate on what you meant?
So Jamie referenced this concept of open licensing, by which we meant, so there's, you know, if we want to get into the legalities of compulsory licensing, there's, strictly speaking, there's a compulsory license where it's supposed to be generally a third party. The idea is a competitor, a potential competitor with the patent holder would request a license to sell their product as well. And then separately, you've got government use authority, the government's ability to simply make use of any patented product at any time for state purposes, and then essentially authorize contractors to make the generics if needed. The open licensing figure is sort of one to, so the state can adopt a policy that says, if applicants, here are our terms, at least as we can see, or Jamie may have a different point of view, but the state, as Ecuador did with sort of Decree 118, can say, our policy is compulsory licensing. If you come to us and you meet these requirements, that license will be automatic, or the patent office will execute it and pay the following royalties. So it's a way of not having to litigate it necessarily case by case or applicant by applicant, and holding out the politics for applicants to come in. So it's actually worked that, you know, the state politics have kind of gotten in the way of us doing this as well as we'd like. In Ecuador, instead, I think it's fair to say, there came to be a politics of domestic commercial prioritization. Basically, we had to overcome, on the one hand, friends of the global patent holders in Washington kind of secretly trying to block us in the government, and then separately, friends of the domestic industry trying to give special favors to their domestic distributors. And so we didn't quite end up with open licensing, but over a period of years, and it really wound up taking 7 years, it was personnel changes at the Patent Office and then the Ministry of Health that finally took full advantage of that presidential decree in state politics to just start an aggressive practice of negotiating with patent holders and issuing compulsory licenses when needed, and centralizing purchases and saving $400+ million, which was a lot of money for a state that size. But it sort of first had to weed out some of the soft political corruption domestically.
If I can just add something on the.
Do you have 1 minute, because we need to go to the poll after that. But please, James, use your minute.
Yeah, it's just on the open versus. I mean, it's to sort of elaborate a little bit on some of the things that Peter hinted on. In Malaysia, a former government official got a compulsory license to import Cipla's product into Malaysia, which he marked up. So he'd buy it at one price from Cipla, and then he'd charge a higher price to his own government. And no one else could import Cipla's products into Malaysia except for this guy. And then I know that in the TAC case in South Africa, they did not want open licenses. TAC didn't. They wanted sort of a negotiation they could use to sort of get more buy-in from the government that there was some South African involved in the making some money out of the thing. And these commercial considerations, as I think Peter's aware of from his work too, it's one of the things that is always kind of a problem area. You're always better off with at least one compulsory license anyhow. But now the medicines patent pool licenses are an example of open license. Anyone can apply to the medicines patent pool, and the company that owns the patent is not in a position to say yes or no over who gets the license. In those kind of licensing cases, when the medicines patent pool is involved, it has a great advantage in the sense that the company gives up control over who is making the product, and it results in a much more competitive outcome. That's it.
Okay, thank you so much. Public, we will go to another poll, and panelists are also, of course, allowed to fill in the poll questions. It's 3 questions again, and please fill them all in. Would you consider the guidelines to be useful for your own goals? Would you consider starting a legal action? Oh, it's 2 questions. Oh, and if you are considering legal action, is anyone considering legal action for access to a COVID-19 vaccine or drug? It's even 4 questions. Well, that's later. Yeah. Okay, so what I get as results on the first question, would you consider the guidelines to be useful for your own goals? 3/4 of the people thinks indeed it will be very useful. Would you consider starting a legal action? 60% says yes, 20% needs more info first, and 70% says I already did. If you're considering legal action, is it for COVID-19 or vaccine or drug? Yes, says 33%. Who would like, and somebody would like to share something about that also. Is that one person? I think it's one person, or maybe more, but the person that says, yes, I would like to share, would you please share with us what you want to say about using legal procedures for your cause? And please be aware that this is being filmed and that it also will be on YouTube, but please tell us some more. So who was the person who said, yes, I want to share some more? Luis?
Well, actually, I don't know if I was the one who put that on the survey.
Well, you should know.
No, because I did it on the run, but as far as I know, James is doing the legal action in Dominican Republic, and we are doing as well, asking the government of Chile to declare that there is a need for a compulsory license for COVID and in particular to Paxlovid. So we are in the way to have a complete process going against Pfizer any time soon, as soon as the Minister of Health declares that there is a need for the license. So yeah, so keep tuned. You know, we are on track.
We will follow what you're doing, and thank you so much, Luis, for telling us that. Now we will allow our panelists to give their last famous words, at least for this webinar, to the audience. And I would like to start with James, because he's always so creative with his 1 minute. So please, James, you have the floor for one more time. James has left us for a second. So then let's go to Peter.
I'm sorry, I can do it.
No, don't worry, don't worry. Okay, there you are, please.
So you want 1 minute. Well, I think if people have never tried to do a compulsory licensing case in their thing, it's good to do at least one case that sort of forces the government officials to actually adopt policies and procedures, which is something you can always do. COVID's a great chance, a great product to do it for COVID is if you don't have Paxlovid at an affordable price. In other words, if you're not in the medicines patent pool licensing area, which is a problem for many Latin American countries and some Asian countries, that would be a good target because there will be suppliers, and that's also a thing. So just sort of getting the ball rolling is always a good idea. And also find out what your Records Act allows you to do in terms of Freedom of Information Act request. I mean, it's cheap, it's easy to do, and they're always fun to get the results back.
Yes, thank you. Thank you so much, James. Okay, the next person to have 1 minute of fame is Peter.
Sorry, was that to me? I didn't.
Yes, Peter, yes, that's you.
Okay, so yeah, I just put a chat in here to this point. I mean, I think, so as the PAF guidelines say, right, we go, first we try with the company doesn't want to act, we go to the government through an administrative request. And if that doesn't work, the courts are our ability to sort of force action there. But there are a couple of challenges. One is the problem of, you know, what is the right that is at stake? Can we defend the right to health? If so, is the right to health collective or individual? And I think this is like a challenge that we can work on as a community. If it's just about getting access to a particular drug, the company can fix that problem pretty easily, give access to the drug, the state can fix it. So what are the sort of collective theories of responsibility of the state to keep prices low or to use the tools that it has? And, you know, we've tried a couple mechanisms there that we're happy to talk about with others further about how we think we can do it. Like, courts aren't going to order the states usually to spend money. It's at the discretion of the state. But if they can save money using their rights under international law, is it different? So.
Yes, lovely. Thank you so much, Peter. Next on my list is Patrick Dewish.
Yeah, thank you. I agree very much with what Peter said previously. I mean, this interaction between legal actions and politics. I mean, the one refers to the other. I would encourage people on this call and broader to have some legal actions going. First, it forces you to know and to study carefully the environment in which you are. I mean, all the laws, etc., and all the possibilities you have. And second, it helps you framing the narrative, basically. Whenever you go into the political fields, having studied well without being you don't need to be a lawyer for that, but it helps if you have a lawyer helping you. But I mean, just to know what's existing, where are the loopholes, and where are the possibility for the governments to intervene, just helps you also with a stronger narrative whenever you have to confront politicians around that.
Lovely, very clear. Thank you so much, Patrick. Last speaker, but not least, is Wilbert. Wilbert, you have your 1 minute.
Thank you. Well, Lydiant, of course, was our first case. We've learned a lot, and we've developed these guidelines for legal action by NGOs based on that, but it's never perfect. So please comment and add cases and add examples and send proposals. Lydiant, in the meantime, has 3 legal cases against the Dutch Health Inspectorate, against the health insurers, and against the Dutch Competition Authority. They have not yet tackled us, but anyway, we'll see. What we are doing, we actually have already put it in the chat to give you
Okay, unfortunately, Wilbert froze, and we're very much at the
away
end of
a
our
little bit.
webinar.
Our next webinar, and this is on the drug that was the most. So if you are interested in that case, actually contact us and see the reference in the chat box on that what we've done. At the moment, we have invited AbbVie to settle the case with us until end of February. So we'll see if they actually are settling or whether they want us to go to court. Thank you.
Yes, thank you so much, Wilbert. And unfortunately, you froze a bit in the middle, but I think people got the idea of what you wanted to say. Okay, so we have come to the end of our webinar, and I hope you have become as inspired as I have. This and our previous webinar have been instrumental in completing our document on guidelines for legal actions, but there still are new procedures to be used. So, like Rosalind and Wilbert already said, this is a living document with updates. And please feel free to make use of this document and contact us when you need more information and/or inspiration. A link to the YouTube version of this webinar will be posted to you and can also be found on our website, as well as all the slides that have been shown. And while you are on our website, please consider if you want to express your support to us and/or receive our newsletter. And this being said, I want to thank the panelists again for sharing their experiences. I want to thank the audience for participating in the event. And I want to thank our sponsor, Unit 8, for making this webinar possible. And I will say again, good morning, good afternoon, and good night.